Thank you. We before we proceed, I want to place on record. When the court reconvened this morning with sentencing proceedings, Dr. Salie-Hlophe was called by the defense, who proceeded to give evidence, which was by and large already before the court. It is common cause that this witness had previously testified before this court with specific reference to the events relating to Mr. Rohde's absence from court on the 5th of February 2018 due to having been admitted to Crescent Clinic. Even though that information is already before me and on record, I had, in an effort to ensure that Mr. Rohde continues to enjoy a fair trial, allowed the witness to place the information and evidence before the court. I duly note the information he so sought to place on record, and I so duly take that into account. However, when it became evident that the witness was not confining himself to placing evidence in mitigation of sentence, and furthermore, that Dr. Salie-Hlophe essentially continued to protest Mr. Rohde's innocence, notwithstanding that this court had already convicted him as charged, I reminded him of the purpose of these proceedings, that is, to place before me factors in mitigation of sentence. Differently put, that information favorable to the accused or to be placed before me will take into account in considering an appropriate sentence to be meted out against Mr. Rohde. Rudely, raising his voice, shaking his body, and wielding his finger in the air. This conduct is highly inappropriate and I hope that Mr. Van Spey had taken full advantage of the adjournment and that the defense is now ready to proceed with the business of the proceedings today, which is, I remind, sentencing proceedings, and to place evidence before me in mitigation of sentence. Thank you. Can we proceed?
Yes.
Dr. Salie-Hlophe, in the olden days, and perhaps not so long ago, there was a stigma attached often to people who had psychiatric complaints or pathologies or received psychiatric treatment. I'm sure you're aware that that is universal knowledge.
Yes, I am.
As opposed to people with organic conditions. And I believe that that has changed with time. In terms of a mental illness or an organic illness, you drew Mr. Rohde, who was lying in terms of medication and heavily sedated, suffering from a major depressive episode, and you drew the comparison with just as somebody who maybe had a myocardial infarct. Do you remember that in your testimony?
Yes, that's correct.
Now, is there any difference in seriousness between a mental illness and a physical illness or an organic condition, as far as the medical profession is concerned?
No, there is very little difference at either of those at their extremes of severity. So, for example, what I mean is that depression kills, for example.
Right. Now, you were intimately involved with Mr. Rohde during that period of his hospitalization. How regularly did you see him?
I saw him daily during the week.
You also mentioned in your report that he was treated in a team context, that the team comprised, as I understand it, yourself, a clinical psychologist, dedicated psychiatric nurses, an occupational therapist, and whoever else.
Yes, that's correct.
And of course, a psychiatric, the appropriate environment. What is the benefit of that sort of team approach, that whole package?
The benefit of the team approach is, first of all, there are multiple eyes, as it were, on somebody with multiple perspectives, and that there are different divisions or, I suppose, job descriptions among those people. The psychiatrist has a specific role and skills. The psychologist has a different role. The occupational therapist has a different role, and the nurses then have their own role. So the benefit of that is that the person has a more robust regimen of treatment and is more likely to get better quicker and be, I suppose, monitored for suicidal ideas or self-harm of any sort. A clinical psychologist also learns about general mental health in its wellness and also in its pathological state, but has a degree which is usually 3 years either of arts or social science, and then has an honors and then a master's in clinical psychology. A psychiatrist, as you outlined before, studies medicine for 6 years, and this is followed by a 2-year internship and then a 1-year community service, and then 4 years of specializing in which we look very, very carefully at diseases of the brain and the mind and learn how to assess people in different ways and to treat them with various modalities, including medicines.
Right. Can a clinical psychologist prescribe medicine?
No, because he or she is not a doctor.
Right. Now, in your close interaction with the accused during that period, let's just say from the 31st of January until you discharged him from hospital, if somebody said to you that he was malingering, what would your comment be as a medical practitioner and a specialist psychiatrist?
Well, I would be surprised on 2 counts. The one would be that it's not just what people say when one assesses how they are, but it's also about learning the skills of observing body language and other forms of observation or communication by the patient, whether it's unconscious or conscious, including assessing concentration, including assessing how they're following a conversation, etc. The second reason why I would totally disregard the idea that he was malingering was because it was not Jason's wish that he should have delayed the trial in any way, and he continued to maintain that position until I insisted that he come into hospital.
Now, initially you checked him or you recommended that he should be booked off for a period of 6 weeks. You will recall that.
Yes.
And then the case was postponed for a couple of weeks, and then you gave the final letter or the report to the court in which, I'm not going to read it, you have to have it on record, it's dated the 20th of February, it's marked Exhibit EE4, and you've come to the conclusion at the end, it's common that he's sufficiently well enough to deem him fit for trial and continue the proceedings. As such, in my opinion, he is presently capable of understanding the court proceedings and conducting the defense of the case. Will I ever need to continue our patient treatment? Were you saying there that he was back to normal 100%? What were you saying there?
No, I wasn't saying that at all. In fact, it would have been improbable. It would be improbable that somebody would become what we call in mental health go into remission. What we would say is that he responded favorably to treatment to the degree that he had moved from a place in which he was extremely anxious, suicidal, hopeless, full of despair, not being able to think straight, to a place in which he felt more hopeful, His mood had improved. His anxiety was diminished. He was sleeping, which he wasn't doing when he first started, when I first saw him. And his concentration was improved, and he was able to think logically, but he certainly wasn't anywhere near what I would call his full level of function, but his functioning had improved adequately enough for him to be then fit for proceedings.
Right. What about the submission that he had a miraculous recovery? Can you comment on that?
I reject that outright, because these are not miracles. This is what we find usually, is that within a few weeks people respond in such a way that is meaningful on all those levels that I mentioned, with respect to sleep, anxiety, depression, and suicidality, and most important, function. This is not a miracle. This was an intense regimen of treatment that he had in a nurturing environment, with psychotherapy with his psychologist almost daily, seeing me daily, and then the other multidisciplinary team members that I've mentioned. This is not miraculous. It's what we do.
Thank you. I have no further questions.
Doctor, on this last point, before now assessing the accused after he's been incarcerated and found guilty, did you treat him further by way of consultations between the time that the trial resumed after this incident that you've now described to us and seeing him after conviction?
Yes, I did.
How many times?
I saw him twice, and I had 3 telephone conversations with him.
When did you see him?
I unfortunately don't have my notes with me, and I would have to get that to you if you'd like. But I have the dates recorded, but not currently.
Can you recall the month?
Yep, I saw him in June, I saw him in August, we had contact in September, and then I had contact with him in November before the sentencing proceedings began.
The first time you saw him in June, what was the reason for the visit?
I wanted us to assess, first of all, whether or not he was on optimal treatment in terms of doses of his medicine. And I was, as I would with any patient, want to follow them up, because they're on doses of medicine which are multiple, certain ones which I would want to have stopped after some time, for example, sleeping medicine. So the purpose of that was really to assess whether he was on enough medicine, the right medicine, that it was having an adequate effect.
Before that consultation in June, when was the previous time that you saw him?
I would have to consult my notes, I'm afraid.
You can't give us an idea, a month?
No, I think it was most likely about April.
And what was your verdict, assessment, outcome, the consultation in June?
My verdict was that he had returned to the mental state close to which he was in when I first met him. That was that he was anxious, worried about the future. He was distressed, stressed, but at no point was he back, and I haven't ever seen him at any stage in a mental state approximating the mental state in which I found him in February during the time in hospital.
Dr. Stoll, in preparing this report before court, double Q exhibit, did you do a test, the Minnesota multiple personality test on the accused?
No, I didn't do that test, and that was not done, no.
Did you do the Rorschach test?
I did not do the Rorschach test. In fact, psychiatrists don't do those tests generally.
Do I understand that doing the test, or did you ever do any of these two tests on him during the course of this year?
No, I didn't. So I worked very closely with the late Miss Diane Nelson, who is an expert in personality. And we had extensive discussions because we were co-managing Jason. And we studied carefully the criteria of the various personality disorders, and he fits absolutely none of them.
But you didn't see the results of a test in this year, either Minnesota or Rosa.
No.
And can you say whether Ms. Diane Nelson did any of these tests?
I'm actually not certain. I'm not sure if she did any of those tests.
As I am advised, am I correct, the Minnesota multiple test, it's a personality test, correct?
Yes, it is, yeah.
Focus on aspects like guilt or avoidance of guilt. Would you agree with that in broad terms?
It focuses on many aspects of personality.
But
yes.
These that I've
Yes.
mentioned
Yeah.
are part of that?
Yes.
And if you do a Rorschach test, you can pick up whether somebody is defensive or projecting. Is that a fair comment if you start doing such a test?
Mr. Van Niekerk, it may be a fair comment. The problem is that I don't regard those tests as being either as effective or superior as in-depth conversations and clinical assessment and judgment in terms of getting to know the patient, working out how it is they operate, what they feel, how they responded to situations in the past, etc.
Now, you stated in your report, page 2, the second paragraph, he's even-tempered, he's neither volatile, etc. Did you follow any of the proceedings during the course of the trial? Read or heard the evidence being given?
Yes, I have followed some of the proceedings.
Have you read the testimony of the accused?
Yes.
Have you read the evidence of the state witness Carol Nader?
Yes.
You've seen her report as well?
Yes.
Mr. Van Niekerk, since I'm going to give you the same mark that Mr. Van spoke, I've pronounced on this. So perhaps at the very best you could ask if the witnesses are fair with the judgment of this court, which convicted Mr. Rohde.
That is the last
we'll
aspect I
get
want
there.
to ask you. Have you read the judgment, specifically the evaluation of the accused by this court? And I'm referring to page 192 and further.
No.
You see, I'll get to the heart of what I'm going to ask you. Comparing to what you've said here in your report. On the 20th of July 2016, there was a session with Carol Nader. You've got her report in front of you?
No, I don't.
I'll just quote from that session, and I'll quote from the exhibit P6, that was a statement handed in by Carol Nader, and it's on the 4th page, paragraph 18. I quote, "On the 20th of July 2016, the session was stormy. Jason stated he was angry and had been forced to attend the sessions. He stated that he did not want Susan to go to the Solid Week conference. Susan insisted on attending the conference with Jason as she wanted the whole company to see them together. I tried to mediate the impasse, but I was unsuccessful. She stated she did not make scenes, and they both stormed out of the session." You remember that?
Yes.
Now, one moment, my lady. he explained his relationship with his mum to you. Is that correct?
Yes.
And he felt that his mum was controlling over him. Is that correct?
I don't recall, but I'll take that word for it.
The behavior that he displayed on the 20th of July 2016, as described, and I'm going to quote from the judgment. I want you to think about that and then explain to us, are you still keeping with your report and your findings that is even-tempered and never volatile as expressed in your report? The court found, and I'm quoting again on page 192 of the judgment, his evidence as to the events between the hours of approximately 7 o'clock a.m. to 8:30 a.m. on the morning of the wife's death was evasive and specious.
Yeah.
Then, in the judgment on page 194, I quote from the third line, using terms such as colliding with the deceased and his body connecting with the deceased was clearly a way of ducking the reality that the accused had assaulted the deceased by using physical force. You understand that?
Yes, I do, Mr. Van.
Then I quote from the judgment, page 195. He became argumentative and belligerent when challenged under cross-examination. And then lastly, page 196, the court explained his behavior that morning of her death versus the behavior that he displayed and how he described it in his evidence when he was arrested. And I'm going to quote. Well, let me start on page 190. You still contain that he is just an even-tempered person, not
Behave in a way that is highly conflictual and brings out behavior in each other which is not general and generalizable to their personalities or their behavior in the rest of their lives. That's the first thing. The second thing is that I strongly believe that he was more than pushed and more than provoked, if you like, in the context of my meeting with him many times and through the proceedings and through the events that have been described around his arrest in hospital. And I strongly believe that that description of what happened on July the 16th is not necessarily indicative of his personality, and I never said either that he was never volatile. I said neither volatile. I didn't say never, because we're all volatile at some times in our lives. But neither volatile as a personality. He's not a volatile personality, in my opinion.
I want to end off, this was the place I was looking for. In the report by Carol Nader on page 4, paragraph 60, the 12th consultation on the 11th of July 2016,
Yes.
she made a note to herself, and I'll quote from that paragraph. I explored the possibility the couple were mirroring what had happened in their childhood. Then she explains about Susan's father, and then she says the following. Jason's mother was controlling, and this led him to being rebellious. Now, don't you find what the court found his evidence to be, as I quoted from the judgment, and what happened at that session on the 20th of July 2016, that this suggests behavior that is repression of other destructive behavior that he can display?
I don't think that you can always assume that anger is evidence of a potential for violence. I think what's really important to, if we relate what you're saying to Professor Abrahams' evidence yesterday about mothers and their sons. It's not controlling mothers, it's harsh, cruel mothers. And Jason's mother's never been described as that. And his childhood was never described as a harsh, cruel childhood. I need to make that clear. This controlling is something which we talk about in many contexts about people who are slightly controlling, but that, I don't agree with that statement.
The impression I get from his evidence and how it was also adjudicated by this court is a person that consistently defends himself vis-a-vis the reality he finds himself in. And that was displayed in the months leading up to the death of Susan, as well as displayed in Carol Nader's report, which he said he continued that relationship, but he held forth that he was working on the marriage. What do you make of that? In the light of that, he said to himself, he said to Carol Nader, this controlling of his mother made him rebellious.
Look, I mean, the inferences that you are drawing, I'm sorry to say with respect, between being controlling, being duplicitous, being deceitful, and it's terrible what people do to each other in relationships. And Jason is deeply remorseful that his, as I believe, his actions, he believes, led to Susan's death. But that doesn't make him responsible for her murder.
I've got no further questions, my lady.
Thank you. Well now, my learned friend elected to go down the route of Mrs. Carol Nader, and you've read her notes, you say?
Yes.
And she testified that in her view, the late Susan Rohde was not depressed.
Yes, that's
What
correct.
do you say about that?
Well, that's...
I must object. I don't know what relevance Susan Rohde's state of mind has in sentencing proceedings. It's about who the accused is and his conduct.
My lady, this is cross-examination that comes directly from the notes of Carol Nader, which my learned friend chose to introduce. I didn't even touch on them in evidence in chief with this witness.
Yes.
He elected to go down that route. Now he doesn't like my follow-up question.
Yes. I hear you, Mr. Van der Sply. I'm not here to disagree with you. But it's still sentencing proceedings. We're not rehashing the trial. I made a decision as to the aspects that were laid before me during the trial. Carol Nader's report was referred to by your learned opponent for the purposes of sentencing proceeding, not to rehash the merits of the case which was decided upon by this court.
I accept the court's ruling.
Thank you.
I have no further questions.
Thank you.
May he be excused, my lady.
You may. Thank you, Dr. Stella.
Thank you, my lady.
My lady, may I just canvass a pressing issue? We have, as the court knows, we had to start late today with the other case that was on here and various other things. I find myself in a difficult position. I have a young girl, Miss Kathy Rohde, KT. I want to call her. I want to try and finish her today, but I don't want to interrupt her testimony. We've also got to deal with an issue, and that is the question of the basis upon which her testimony is publicized or not publicized yet. And I understand that the prisoners have to leave at 3:20ish or something like that to go back to Polesmore. And my lady, I also understand that the next available sitting for this court is in early, or roughly the second week of the first term of next year. Am I correct in all of those statements, my lady?
Yes, that you are correct. It is now getting to the end of term. I've had a meeting with your instructing attorney, Mr. Master, yesterday in chambers, along with Advocate Van die Kerk. And I've indicated that I have a judicial commitment during the first week of term, which is full bench appeals, followed by a trial, followed by the next available date, which is the 18th of February, to continue with this matter. At the time when I'd met with them, I indicated that we could possibly look into rearranging matters, but that matter has this part heard as well and has been set down previously.
And my lady, there's a further aspect, and that is, if there is going to be such a long break, then I want to apply for bail for that interim period. And I don't know that we can fit all of that in the next half an hour. May I? My instructing attorney wants me to call Ms. Rohde, if at all possible, to get her over with. I think that I'm sure the court will understand. I do, in a sense. I've also had a young daughter in my time, and this is a major issue for a child, torn between a deceased mother and an accused and a convicted father, and wanting to do the right thing and being also, I think, finding herself in the middle of in-laws on both sides. So it's a traumatic experience for her. So maybe I can start by saying to the court, I don't believe that I need to bring a court application to have her evidence done in camera, or to have a court order that no information relating to her may be published, including live streaming or audio reporting of what she says and her testimony, because there is an existing order. And the existing order is very clear as far as I'm concerned. My problem is my learned friend, we've approached him 2 or 3 times, and he's repeatedly said that he is going to insist that her evidence is published and is subjected to live streaming. Now, as I understand the legal position, for that to be possible, my learned friend has to apply to you for an order changing your previous order. And with regard to the learned court's previous order dated the 9th of October 2017, paragraph 4 seems to me to be operative, where it says, none of the arrangements above, that is for live streaming and publicity and publication and so on, shall be extended to the Rohde children, in respect of whom no photographs, audio recordings or video footage shall be taken before, during or after the hearings, whether they are present as a witness, member of the gallery, or in any other capacity. And then, furthermore, incidentally, I notice with interest, no exhibit shall be photographed, videotaped, or published by the media except with permission of the judge. And that seems to have been more complied with in the breach than in the observance. Nevertheless, as far as the children are concerned, this order was made at a time when the 2 twins were under 18, but at the time when this order was made, Kathy Rohde was already 18. She was already a major. So as far as I'm concerned, I don't need to apply for an order, and I will proceed to ask leave to call Kathy Rohde immediately on the assumption that nothing she says will be broadcasted or live streamed or anything similar. But my learned friend has, at least on 3 occasions, indicated that he will insist on the contrary approach. And I'm just mentioning that because I don't want there to be any uncertainty.
Thank you. Mr. Van die Kerk?
Yes. Lady, I'm, in respect to the existing order, what I would like to draw the court's attention to, at that time, as I understand it, there were no question of any of the children being called as witnesses. The situation has changed a bit. There's been a conviction, and now one of the children is being called as a witness. And she's, I understand, around 20. One looks at Section 153 of the Criminal Procedure Act, circumstances in which criminal proceedings shall not take place in open court. I think that the heart of the issue is here, and it's in the discretion of the court. Paragraph 2, section sub 2. If it appears to any court at criminal proceedings that there is a likelihood that harm might result to any person. And I haven't heard anything about harm other than in general. And I'm not going to belabor this point. I've told the court that it's my instructions in the office. We've discussed it. We don't want to set a precedent for other witnesses in a similar position. Each case has to be adjudicated on its own terms, and those are my submissions, and I'll leave it then in the hands of the court.
Thank you.
Thank you. My lady, my learned friend has said he hasn't heard any suggestions forthcoming from me about potential harm to the witness. But I haven't brought an application. All I'm saying is there is an existing order, and I will expect my learned friend in letter and spirit to comply with that.
Thank you. But in my assessing the amendment which is seeking, I would assume that your view is that it's harmful to Catherine Rohde.
Well, my lady, we have an incredibly vulnerable child here. As I said, caught between the devil and the deep blue sea. It's perhaps not the most appropriate comparison to make.
I understand.
And who is very reluctant to testify. She's as frightened as anything. And she's fearful of sanctions and input and comments from her friends at university and wherever she's going to be next year. And initially it was her approach that she would only testify if it could be done in the confines of the judicial people involved. She has now indicated that even if the court says her evidence will be broadcast, that she will testify, but it will be with considerable fear and reluctance.
Okay, thank
And
you.
she can say that herself with ease when she comes into the witness box.
Thank you. How long do you think her evidence would be? Would we be able to fit it into today? If we sit till 3:30?
My lady, it depends on how long we are going to sit. If we're going to sit only for 20 minutes, we'll probably finish her in 15. Her evidence in chief, I don't know what my learned friend is going to do then.
Thank you. You've raised this with me. Thank you. You've raised this with me yesterday in Chambers, the issue of, at the time I understood that you're going to seek that her evidence be held in camera and free of media access. So I prepared all something. Nothing has come from counsel that persuaded me differently. So I'll read it into the record, and then we can proceed with Ms. Rohde's testimony.
As it was, please.
This is the sentencing proceedings pursuant to this court having convicted Mr. Jason Thomas Rohde of the murder of his wife, Mrs. Susan Frances Rohde, and defeating the ends of justice by staging her death as a suicide. By agreement between the parties, the state commenced yesterday with the calling of witnesses in aggravation of sentence. The state called 3 witnesses whom testified yesterday. Today, the defense proceeds with its witnesses, one of whom would be Catherine Rohde, presently aged 20, and the eldest daughter of the late Mrs. Rohde and the accused. Yesterday, I was informed, which is not the case today, notwithstanding, I will consider the provisions of Section 153 of the Criminal Procedure Act, Act 51 of 1977, whether her testimony ought to be held in camera. The state opposed the application, which I understand now is not an application, but the state is bringing an amendment of my previous order, but no special circumstances exist warranting the granting of an amendment of my previous order. In support of the application, the defense would undoubtedly indicate that special grounds exist for this young adult to give evidence behind closed doors, barring access to the media. There are a number of seminal judgments that guide this court in deciding this application. Furthermore, this court has the discretion to decide the application on the specific facts present in the case. In S versus Matlovu and others, 1978, volume 4, SA 218E, it was held that the prerequisites, which is must be an anticipation of harm to the witness who testifies, but it must be a reasonable possibility, not just an anticipation of harm, and it must not be a remote or far-fetched one. In weighing the surrounding circumstances, the court is not bound to consider and evaluate only the factual evidence placed before it in direct proof of the likelihood of harm resulting. The court can travel beyond the mere facts of the case and may draw upon its own judicial experience in other cases of like nature. The court will consider the nature of the charges, in this case, the convictions of murder and defeating the ends of justice in respect of the witness's father, the atmosphere of the case, and the prevailing circumstances. There must be a causal connection between Catherine giving evidence and the possibility of harm to her. Now, in Detroit's commentary on the Criminal Procedure Act states that it is in the interest of justice and not just the protection of the witness that are the primary objectives in the exercise of discretion by the court. It is undoubtedly the case that Catherine finds herself in an unimaginably difficult and painful situation. Though she is an adult, the court acknowledged that her testimony would be on matters which are sensitive and traumatic for her. The court is alive to the position she finds herself in. A number of factors must be considered by me in an endeavor to ensure that the witness is afforded a reasonable measure of protection, whilst at the same time ensuring that the interest of justice is not compromised. An in-camera proceeding, or a proceeding disallowing the press, has been considered by me. This brings me to the consideration regarding media access. The guiding principles, I am of the view, would in many ways overlap between granting access to the public on the one hand and to the media on the other. Our Supreme Court of Appeal had dealt with the age-old principle of open justice with developments in modern communications technology. Broadcasting cases is constitutionally mandated, flowing from the right of freedom of expression, media freedom, and the right of open justice. Justice must not only be done, but it must be seen to be done. The right to freedom of expression goes hand in hand with the principle of open justice. The default rule to allow public and media may be departed from only if the circumstances warrant it. The competing rights on the one hand, being media and public access, must be carefully weighed with the rights of the protection which Catherine is seeking from this court. In so doing, I have considered other alternatives which would offer her a reasonable measure of protection. This would also accord with the guidance offered by the Supreme Court of Appeal, which proposed that the presiding judge is required to consider other alternatives to live visual coverage, such as audio or delayed broadcast. In the result, I considered all the factors and circumstances before me. I am satisfied that the proceedings in relation to the testimony of Ms. Catherine Rohde shall continue as an open proceeding with my order dated the 9th of October 2017, vis-a-vis media access remaining in force with a specific reference to paragraph 4 thereof, however amended, hereby to allow the testimony of Catherine Rohde to be live recorded, subject further to the order that cameras are prohibited from focusing and recording on her whilst in court. Thank you.
As the court pleases.
You may proceed to call it in.
As the court pleases.
So, does the media understand my order? You can report anybody you wish, other than Ms. Rohde. You may audio report, yes.
Catherine Francis Rohde.
Do you have any objection? You swear that the evidence or I should be the truth, the whole truth, and nothing but the truth.
So help me God.
My lady, may I just ask the witness to be seated while I address the court? My instructing attorney has mentioned to me that he explained the ruling relating to publicity to the witness as he was walking in here, and she indicated to him that she doesn't want to testify anymore. She's too frightened. May I ask for a 5-minute adjournment that I get clarity and instructions? I don't want to force her into the witness box. That's the last thing. I'm sorry about this.
Give an opportunity and we'll see what we can do.
Thank you, my lady. I appreciate it.